Me welcome Sharad. He's always been a part of us. Good to have him here. He's done a fair bit of GST amongst other things, but GST is a subject which one has had a very large impact in the last 3 years. The work's going to grow exponentially from here, and it's a subject which most of us don't know much about. The controversies have been coming thick and fast. Problems have been coming thick and fast. So that's an opportunity for. I may sound like the devil, but we are devils at the end of the day. That you'll have to find opportunities in the miseries of others. And GST is fairly large on the count. So good. Over to you, Sharad. We're very happy to have you with us today.
Thank you, Bhaiya. Thank you. So, as the topic itself suggests, that it is basically an overview. It is going to be a primer on things. We are going to, I'll basically be sharing my experiences, the kind of problems I have faced, with a little bit of background information on how the GST was brought into force, coupled with the fact that what is the basic concept of GST. So let me start with a question. Actually, the thing is that I would want it to be a little interactive, but I doubt if it can be made interactive. In any case,
we'll try, Sharad. Let's see how it goes.
Okay.
So we just don't want to make it chaotic because we're still not used to this online thing.
Right.
But we'll try. If you have any questions or something, then maybe somebody can.
Okay. So, before
we can do a question and answers round after the talk has completed by Shazia.
Right.
That will be like better.
Okay. So it's basically a sum total of the kind of problems which are there. But before that, we'll start with a little bit of background. Now, most of us would be aware that GST was brought into force on 1st of July 2017. Now, how GST was brought into force and how many acts are there through which GST has been implemented? When we started working on GST, there's one of the very important questions which came into my mind was that why did we need a constitutional amendment to bring in force this GST regime? As we're all aware, there's 101st Constitution Amendment, which was there. And after this 101st Constitution Amendment, the GST regime was brought into force. Now, this 101st Constitution Amendment is very interesting. If we see this 101st Constitution Amendment, how we understand is there is division of power between the center and the state. And we understand that 7th schedule basically gives out the fields on which legislations and taxation can be brought in by the center and the state. Interestingly, this Constitution 101st Amendment does not amend the 7th schedule by inserting the GST field. It does not add. Of course, it does take away. It omits certain fields, it omits certain entries, but it does not add. On the contrary, what it does is, it has added substantive provision in the Constitution itself. So there is this substantive provision which says that how GST will be implemented, who will have the right to recover, how the tax which is collected will be shared, how there is going to be a body which will be in the nature of cooperative federalism, as we say. So there is this body called GST Council, which has been constituted. This body comprises of the union and the states. All these states have their representative. The chairman is the union finance minister. They all sit together. They are supposed to take decisions as to how to implement the GST regime. But more importantly, the question which I have been facing is that why per se did we need this amendment? I'll take you through some important aspects of the amendment. This 101st Amendment Act, it is principally inserts Article 246 capital A, Article 269 capital A and Article 279 capital A. These are the primary amendments. Now, 246 capital A is the substantive provision through which we have given the powers to the central government, the parliament, as well as the respective state legislatures to enact the laws and to have the power to recover the tax. Now, if we see 246 capital A says special provision with respect to goods and services tax, notwithstanding anything contained in Article 246 and 254. So it is a non-obstant clause, and why it becomes important is there is Article 246, which talks about the powers of the union and the state, and Article 254, which talks about repugnancy. So this is the most important aspect. It says that regardless of the privilege and the prerogative available with the union in terms of the repugnancy test, so it says that if there are two laws made by the center and the state, and if there is inconsistency between the laws made by center and the state, the law made by center will prevail over the law made by state. Of course, we have the concurrent list, and even for the concurrent list, this is what was envisaged, that if the union and the states both come out with the law on the same subject, and if there is any inconsistency, the law made by union will prevail. The beauty of the GST regime is that it empowers both union and the state to make their laws, and it gives them adequate space that even if there is some sort of inconsistency, even if it is falling foul, or I'm not, it's not the right word to say that falling foul, but even if it is so that repugnancy is kicking in under Article 254, still both the union legislation as well as the state legislation will be allowed to exist. The reason behind this is that they, as of today, though it so happens that they have constituted the GST Council. GST Council consists of all the states and the union, and they take a collective decision. They sit together, they decide that how we have to harmonize the GST framework within the country. But there was an eventuality and possibility, and there is still an eventuality and possibility that union might come out with a different rate schedule and states might come out with a different rate schedule. So as on today, it cannot be ruled out that the rate schedules in GST can be or have to be uniform. So for instance, if I say that as on today, assuming, I'm just giving an example because I'll be explaining what the concept of tax is. But as on today, if the union government charges, let us say 9%, the same 9% rate is replicated by the states. So the total rate of GST is assuming 18%. It is 9% union and 9% state. The question which I have been thinking is it possible that one day union said that, yes, I will be charging 10%, and the state said that on the same product, I'll be charging 5% or maybe 15%. Is that a possibility? I think it is a possibility because they have given it the repugnancy test to go by. Coupled with the fact, but at the same time, when this kind of provision has been inserted, it also forces us to think that is there a how this kind of a conflict, if it ever so emerges between union and states, how can this conflict be addressed? And to address this conflict, the idea was to constitute GST Council. And one of the most important award object of the GST Council is, I'll just read one, there are various ones. It says that while discharging the functions conferred by this article, the GST Council shall be guided by the need for a harmonized structure of goods and services tax and for the development of a harmonized national market for goods and services tax. So the idea is that though union and state both have been given their own fields to exist, their own competence has been defined to levy the kind of tax they want, but in the end, a GST Council has been constituted, which has been entrusted with the power and function to harmonize this kind of levy and harmonize the exercise of power. Keeping it a little more simple, now I'll just give a brief background on how GST has been implemented. So in pursuance of this constitutional amendment, then came 4 different acts. 4 different acts are the CGST Act, that is the Central Goods and Services Tax Act. Then there is the IGST Act, the Integrated Goods and Services Tax Act. Union Territory Act is nothing really different. It is just one of the forms of CGST Act applicable to the Union territories. And the last and the most important one, not the most important, but one of the most important ones, is the Goods and Services Tax Compensation to States Act. The foundation of all these four acts was basically laid in the constitutional amendment. Now, what is the requirement of having these multiple acts? Why did we need these multiple acts? Why four different kind of acts when all of us have been saying that this is one nation, one tax, and it is simple, good? The Prime Minister said that it is a good and simple tax. So why did we actually need these four different enactments? The reason for us to understand the relevance of four different enactments is we need to go into the flashback. Before GST was introduced, as we are all aware, different incidents of taxes attracted different incidences attracted different kinds of taxes. So manufacturing attracted a different tax in the name of central excise. That was the prerogative of the union. States were given the power to levy tax on sales, entertainment, luxuries, etc. Union had some other. The idea was that all of these taxes should be harmonized. There should be one nodal agency which is implementing all of those taxes. It should be made more consistent. It should be made relatively easier for the businesses and the industries to follow the rules. There shouldn't be multiple compliances. So the idea was that, and coupled with that, the next objective was to make sure that if the tax is paid in the beginning of the chain, as we move across the chain, as the value addition keeps on taking place, no doubt, at every step, tax has to be paid, but at the same time, the person who's paying tax at every stage may also get the opportunity to claim the credit of the tax which he had paid at the time of purchasing the commodity and adding value at this point of state. So they said that because earlier the position was that if the manufacturer had paid excise duty, then when the goods are purchased by the dealers and the sellers, and if they are making the onward sales, they were not in a position to claim the credit of the excise duty. The credit of the excise duty was allowed only to the manufacturer who could claim it as Senvat credit, but it was not available with the second state dealers, or for that matter, the trading dealers. What was available to them was that they could have paid the VAT, and at every stage of VAT, they were allowed to claim the credit of the input tax paid. To make sure and to remove the cascading effect of these taxes, the entire exercise was formulated, GST was thought, and now what we are doing is that right from the manufacturing to the last customer, because it passes through a chain of people, chain of traders, chain of various people interested in various transactions. So by the time the goods reach the hands of final customer and consumer, lot of value addition has taken place. And at every stage, it is stated, GST says the enactment permits that credit would be taken and net tax has to be paid. Now, when this happened, so now what we are seeing is that there are four enactments. CGST Act is the Central Goods and Services Tax Act. So this is the act. In principle, I'll just say in common parlance, it's not a strict view which I am saying, but in common parlance, CGST Act is actually nothing but harmonizing the erstwhile excise regime in the GST form. So what was earlier the Central Excise Act and the revenue which was derived from Central Excise Act is now replicated in the form of CGST Act. So CGST would essentially take care of the government revenue, which the union is essentially foregoing for the replacement of excise. As a matter of fact, the government would be getting more in CGST because the rate of tax is more and the coverage is more. In this is the CGST part. Then there are corresponding state legislations, which are the RGST or relevant state SGSTs as we call them. There the state has made the provisions. but that enactment mostly takes care of the state part, which is state has foregone the VAT, entertainment tax, luxury tax act, entry taxes, all of those taxes. The state seeks to replenish the loss which they are incurring on account of foregoing those levies. Then is the Integrated Goods and Services Tax Act. That element is to take care of what we earlier had the CST, that is Central Sales Tax. So when there is a sale in the course of interstate trade, in such a situation, who is competent to levy the tax on that transaction, and how the money which is recovered from such levy has to be distributed. That aspect, which was part of the CST regime, has been brought in the Integrated Goods and Services Tax Act. And the fourth legislation is the Compensation to States Act. Now, this is the enactment because when GST was on the drawing table and it was discussed, and it was apparent on the basis of research that the states are going to lose revenue. There is a chance and possibility because a lot of tax, a lot of liberty which was available to states to levy different kinds of taxes, to levy taxes at different kinds of rates, that may have to be foregone, and states may be at a loss, especially when they were not sure how GST is going to unfold. Assuming the rate of compliance of GST is good, or assuming if it is not so good, and if the states are at loss, how that loss will be mitigated. To make sure that this loss is taken care of, the Compensation to States Act was enacted. Now, the basis of this Compensation to States Act is very interesting because this is one of the constitutional problems, not problems, this is one of the constitutional issues which all of us will have to look into. The Compensation to States Act has been enacted in pursuance of Section 18 of the Constitution 101st Amendment Act. Now, Section 18 of the Constitution 101st Amendment Act does not ipso facto amend the Constitution. It is very interesting if all of us will have a look at Section 18 at our convenience. Section 18 does not say, it is neither attempting to insert a provision in the Constitution, it is nor intending to delete a provision, neither is it altering any provision. It is simply making a provision in the Amendment Act without giving the corresponding location of that provision. So the Amendment Act says in Section 18 that the union will have to compensate the states in a formal language. But what is the positioning of this provision? Nobody knows. Where is it going to find a mention in the Constitution? Nobody knows. It is probably going to remain in the Amendment Act. And because it comes with a sunset clause, which is of 5 years, there is all likelihood that after 5 years, this provision will itself become part of the history. Be that as it may, using this provision, Section 18 of the Constitution 101st Amendment Act, this Compensation to States Act has been brought into force, and it gives some sort of certainty, it gives some sort of assurance to the states that their rights are protected not just in this act, but seemingly also in the Constitution by way of the Amendment Act. So we have seen how the Constitution Amendment Act was necessary, and in pursuance of the Constitution Amendment Act, we have seen that 4 different legislations have come into force, and how these 4 different legislations are operating various fields and how they are trying to mitigate the losses and at the same time garner revenues for the government. Coming to the concept of GST, though we have discussed a little bit of it, all of us feel that GST, as the name suggests, it is some sort of tax on goods and services. But it is in a way misnomer. It is not a tax on goods and services. It is basically a tax on supply of goods and services. So please note, it is not a tax on sale of goods and services. It is neither a tax on transfer of goods and services. It is a tax on supply of goods and services. It is very, very important. And why I call it a misnomer is because there was a sales tax. By the name, it was apparent that it is a tax on sale. There was value added tax. By name, it was apparent that this is a tax on value addition. But this is a tax called goods and services tax, and this is not a tax per se on goods and services. So some goods are lying in my custody. Just because there is this tax called goods and services, it would not automatic those goods would automatically not attract a levy. Tax would be attracted only when there is a supply element associated with the goods and services. So if there is a supply of certain goods or supply of certain services, or there is a composite transaction where there is supply of multiple kinds of goods, multiple kinds of services, or goods and services combined, then in such a situation, the levy would be attracted. The next question I ask myself most of the time is that why was it necessary to make it supply and why not just sale? Because that is how we were understanding it. But again, the idea was that the term supply is far more wider, and it brings within its ambit all of those eventualities which were earlier taken care of by different set of enactments. So supply takes care of the manufacturing part to some extent, not actually manufacturing part, that is the wrong way to put it across. It takes care of supply of goods from the factory. So the moment the goods are released from the factory, the supply element takes care of that. And once those goods and the movement of the goods, then it starts. Once the goods start moving at every stage. So for instance, what happens if the principal sends goods to the agent? Whether it will be covered within the ambit of GST or whether it will not be. But because the definition of supply, which is provided under Section 7 of the CGST Act and the corresponding enactments, it covers within its ambit any kind of supply, any kind of movement of goods, which is even without consideration, and even if it is within the organization from depot to depot or from principal to agent, all of them fall within the ambit of supply. So the situation is that earlier, if I was making a depot transfer or if I was sending my goods from the principal to the agent, there was no incidence of GST. I mean, it is a different case that remissions and exemptions are given. But as on today, if there is any movement from the principal to the agent or from one depot to the other, it will fall within the definition of supply under Section 7. But then, so if it was so all encompassing, if that is the idea, then why certain more clarity was required? Because if you'll see how the act has been designed, it is there are certain clarificatory schedules which have been appended to the act. So though the definition of supply is wide enough, yet the legislature or the parliament thought it appropriate that it is important to clarify certain aspects so as to remove any possibility of ambiguity whatsoever. Now, when we are talking about that Goods and Services Tax Act is mostly about supply of goods and services. So naturally, a supply of service as it is falls within the ambit. And why is it that any employee so the question is that whether an employee rendering services to the employer, whether this employee will fall within the ambit of goods and services tax, whether GST has to be recovered or charged on such a relationship. At the same time, there are some other clarifications also, and this is what is clarified by the schedule. So if we see the Schedule 1 and Schedule 2, they clarify what kind of activities are to be treated as supply. So though the definition of supply is wide enough, but this is the principle-based definition of supply under Section 7. What the Parliament has sought to do thereafter is that they said that at times it may be difficult to use the principles to come to a formal opinion about a particular activity, goods, or services. What they did was they said that let us clarify certain important aspects. So there are certain things which need to be excluded specifically from the ambit of supply. There are certain things which need to be specifically included within the ambit of supply because they fall in the gray area. So they have added these schedules. These are Schedule 1, Schedule 2, Schedule 3. And they're interesting and important because they clarify a lot of things. For instance, Schedule 3 says services by an employee to the employer in the course of or in relation to his employment, it will not be considered as supply. Interestingly, there is another question, and I sometimes fail to understand this kind of classification by the legislature. So the services which are rendered by the court, we are going to the court, the courts are dispensing justice, the service which they are rendering, whether this service would fall, this kind of service would fall within the ambit of supply of service. The clarification is there in Schedule 3, it says that such a service will not fall within the ambit of supply, but it limits it only to the court or tribunal established under any law. The interesting thing is that an arbitral tribunal is seemingly excluded. So if we are taking the services of an arbitral tribunal, there is a likelihood, and as what I have, to the best of my knowledge, there has been a subsequent notification which clarifies that in cases of arbitral tribunal, though on a reverse charge, but GST would have to be paid, but not on the courts. So for clarity, we can always turn to Schedule 1, 2, and 3. They make certain things clear, because there are certain services which don't even look like services but have been brought within the ambit of GST. There are certain services which actually look like services and are services, but they've been kept out of the ambit of GST. Now, there is another thing. I mean, I'm broadly touching upon some key ingredients of this. So once we see that the Constitution gives certain powers, we have seen how the definition, what is the definition of supply. The next thing is that when all of this was designed, why petroleum, alcohol, and other such goods, similar goods, have been kept out of the purview of GST? And where is it mentioned in GST? So for our reference, we can always see Section 9. In Section 9, it has been clarified that they are kept out of purview, even though they are goods, even though they are one of the, I mean, they are highly traded, a lot of transaction takes place, but they have still been kept within the purview of the earlier acts. So the state, even today, reserves the right to levy VAT on trading or transaction or sale of HSD, petroleum, gas, etc. And similarly, Union has its own powers of customs and excise on manufacturing and distribution and sale, the way it is structured. But why has it not been brought within the ambit? This is more of a economic reality, or maybe a question which can be answered on the economic side, but not on the legal side. Why I have pointed this out is because this is, as we will discuss in the next stage, one legal issue emerged from this situation. What had happened was that the earlier enactments were repealed. The new enactment, the GST regime, had come into force, and it was, a view was taken by the state government and the central government that since the earlier enactment has been repealed, the CST Act also stands repealed. And in the CST Act, there was this concept of concessional sale on the strength of C form. So if a purchaser is purchasing a commodity, a particular good, he had to issue a C form to the seller. On the strength of this C form, the CST Act concessional rate of 1% or 2% was only charged. This is the mechanism, this was the mechanism provided under the CST Act. What happened after bringing into force of GST, the state and the center took a view that since the earlier enactment has been repealed, yet petroleum, diesel, and natural gas, they continue to be traded and sold and covered under the respective earlier enactments, that is VAT, etc., CST. Yet the central government and the state government said that we will not be issuing C forms, we will not give you the benefit of concessional sale. For the simple reason, they were of the view that once GST has come into force and once the earlier enactment has been repealed, that mechanism itself of the concessional sale stands repealed. The controversy was, came before various courts. It was before the Rajasthan High Court also. But the first and the most authoritative pronouncement was by the Punjab and Haryana High Court, and that was followed by the Rajasthan High Court, and subsequently even Supreme Court affirmed. All of those courts decided in favor of the SSE, saying that C form has to be issued because these are those goods which have not been brought within the ambit of GST. These goods continue to be governed by the earlier enactment. So the earlier framework will continue to guide their sale. And if a person wants to take the advantage of the concessional rate, he will be given the advantage of concessional rate. There is an offshoot of this controversy which is again brewing up. Now, the offshoot of this controversy which we may come across in times to come is that though in the earlier round of litigation, it was essentially in relation to certain manufacturing or mining activities. So it was said because the section itself permits C form for certain specific activities like mining, manufacturing, electricity distribution and generation, etc. A kind of controversy arose before the Madras High Court, where it was told that though the person concerned is not a manufacturer, he is into, let us say, a hospitality industry, but he is purchasing diesel in bulk for his generator to generate electricity to be consumed captively. Whether he will get the benefit of C form concessional rate of tax or not, this controversy, though it has been decided in part by the Madras High Court in favor of the SSE, yet the controversy has not seen authoritative pronouncement anywhere. This is probably we are going to face. Now, I'll quickly move on to some of the issues which we have faced once the GST regime has been in force for the past 3 years. And most of these controversies are in the nature of interpretation, pure questions of law, coupled with the fact there are some timelines. So the first set of controversies which we faced, they were in relation to the timelines which were prescribed by the enactment. And as we have all seen, that this is an enactment where migration from the earlier regime to the present regime, we have seen a migration. So if I was a manufacturer, I was paying excise duty in the earlier regime, and now when I am shifting to the GST regime, how this transition has to take place. If I was a simple trader, a seller in the previous regime, and I was supposed to pay VAT, and now when I am shifting to the GST regime, how the transition has to be made. So the first set of controversies which came, they were in relation to these transitional provisions. And one of the most important aspect of these transitional provisions was, though the acts specifically built in the transitional provisions, and they said that traders or manufacturers who were registered or even who were not registered in the previous enactments, to some extent, they will get the benefit of the accumulated credit of tax which they have already paid. So if I was a manufacturer and I have stocks lying with me, I have manufactured the stock and I had paid excise duty, not just excise duty, but if on the purchase of inputs, I had paid tax, and that tax is standing to my credit as a manufacturer in the excise regime. When I'm moving to the GST regime, what happens to that accumulated credit? Similarly, if I am a trader and I have been paying tax, when I'm purchasing the goods, I am a purchaser and I have purchased in the previous regime, when it was the previous regime, I had paid input tax. Now, what happens to that input tax which is accumulated with me when I move to the GST regime? Section 140 of the CGST Act is the section which is the primary section which deals with this kind of a transitional provision, how this transition has to be handled. And the provisions say that yes, the assessee will be allowed to take the credit of that accumulated input tax lying with him. However, a host of conditions are prescribed under section 140, read with the rule 117 of the CGST rules. So the substantive provision is section 140 and the procedural part is captured in Rule 117 of the CGST rules. The controversy which arose now, so the rules again, they said that how the benefit has to be claimed, how the transitional credit has to be transferred to my electronic credit ledger in the GST regime. So the first threshold was that the SSCs were supposed to file TRAN forms. These forms are called transitional forms. The short form, they have been labeled as TRAN form. So there is TRAN 1, there is TRAN 2, and there is a TRAN 3, but TRAN 3 is not part of GST. It is another controversy we will deal with sometime later. So there is this TRAN 1, and we were required to file TRAN 1 forms, and the government said that yes, you can take the benefit of the credit provided you file TRAN 1 within a given deadline. Initially, the deadline was for 30 days, and it was extended. Eventually, it was made 90 days. That is, the deadline was ending on 27th of December 2017. So this date is very crucial. Most of my friends, I'm sure they are aware of the entire set of controversy. So this 27th of December 2017 was the deadline by when TRAN forms were supposed to be filed with the authorities, on the basis of which I could have claimed the accumulated input tax credit. And again, the respective provisions, they provide a mechanism as to what extent, what is the proportion of accumulated input tax credit can be claimed. Now, be that as it may, the real problem arose because people, a lot of the entire GST framework, the compliance part of the GST framework is mostly online. So everything has to be now done online on the portal, and naturally this form had to be filed on the portal, and because of the load and because of maybe not a good infrastructure, the website or the portal was not well equipped to handle the kind of pressure. Seemingly, it so happened that many of the SSCs could not file their form, they could not upload their form because of a lot of technical difficulties. So the first set of controversy which came before the court was, people came to the court saying that yes, we tried uploading these forms, but we could not upload the form because there were technical difficulties, because there were technical glitches. So I am trying to upload the form, but the portal shows some sort of an error. The people said that I am trying to, the situation turned so that when a person is uploading, so because it required a sort of knowledge and understanding of the portal and how the compliances are to be made. So normally the CAs were doing this on behalf of their clients, and there are multiple, if one CA who's trying to upload the form for one client, and there are 5 different clients waiting in line, and if this one client he's also not able to upload the form, it so happened that the other clients did not even get the opportunity to even try. So the CA did not try for all of the other clients, and he said that because I'm not even able to log in for one client, the website is stuck, the portal is down, the server is not reachable. It is not reachable for one, it is not reachable for all. Now these are the arguments which came before the court. The court said that yes, this is something which has to be seen from various angle. It has to be seen from the angle of vested right. It has to be seen from the angle of legitimate expectation. It has to be seen from the aspect of form over substance, whether form should be given precedence over substance, whether procedure should be given precedence over substance, things like that. And very interestingly, if I may say so, Delhi High Court, Tamil Nadu High Court and Gujarat High Court, they were the first High Court. They've taken brilliant and very, very bold view, and they have gone to the extent of saying that 117, Rule 117, which sets this timeline, this is only a procedural timeline, and it would not mean that even if a person, even if the SSC is not able to upload the form within this procedural timeline, it would still not mean that his substantive right of claiming the input tax credit can be taken away. Delhi High Court has gone to the extent of saying that 300 capital A, so denying a person the right to claim input tax credit is akin to taking away, violating his right under Article 300A and depriving him of the property without the authority of law and things like that. So there have been issues, yet the courts have taken divergent views. Most of the high courts have taken the view in favor of the SSC. And in one of the cases, Punjab and Haryana High Court, which took cue from the Gujarat High Court judgment, that matter subsequently recently reached the Supreme Court. and Supreme Court has refused to entertain the SLP filed by the government. So the law to that extent has been settled in favor of the SSE, but the problem is that it is an in limine dismissal. So it is not a reason, it's not a well-written full judgment. It's not the authoritative pronouncement by the Supreme Court. Unfortunately, that has not been the case with the Rajasthan High Court. Rajasthan High Court has taken a little bit of different view. Rajasthan High Court, because various other high courts were earlier giving the direction that you please make a representation before the GST Council, let the GST Council decide, because GST Council is better equipped to know whether you even tried or made the effort of filing or uploading the form. So the view was that if you have not even tried uploading the form and you want to take benefit of your own disability, that should not be allowed. So with that view, Rajasthan High Court directed the SSEs to go before the GST Council. GST Council, after assessing, gave benefit to certain assessees and refused the benefit to some of them. Again, a second round of litigation came before the Rajasthan High Court, and it has been decided, partly decided, and the controversy remains partly alive. So this is something which we will have to see how the Rajasthan High Court ultimately takes the view. The again, some other controversies involved, they were again in relation to section 140, because section 140 prescribed a lot of conditions for taking the benefit of the input tax. So they said that yes, if you want to take the if you want to avail the benefit of input tax, you will have to take the benefit within given timelines. So it is not just the filing of the form, but even they said that in certain cases, I am just talking about a certain case, which is section 140 subsection 3 clause 4. It says that in certain cases, when we are trying to take the benefit, we are trying to avail or claim the input tax credit, in those cases we can only claim that benefit in relation to goods which were lying in stock with the trader or the SSE for the period of 1 year before coming into force of the GST regime. So basically, it says that on 1st of July 2017, when the GST regime came into force, for 1 year, if we go 1 year back, that is 1 year prior to coming into force of 1st of GST regime, all those goods which were lying in stock, only in respect of those goods, we could claim the benefit of tax credit, input tax, we could avail the input tax. Now that is also under challenge before various high courts. This is under challenge. This timeline is under challenge before the Rajasthan High Court as well. And if I recollect properly, I think Gujarat High Court has held in favor of the SSE and said that this kind of timeline is not proper. This is something which again takes away the vested right of the SSE. There is again the rule 117(4)(b). It is a different kind of condition. This condition is it provides a timeline of 6 tax periods. So for 6 tax periods, we have to I can avail the benefit of tax credit within 6 tax periods. So this timeline has also been challenged. This is sub judice. It is yet to be determined by the courts. I have already told you about the C form controversy. Then there is some interpretation part under section 143. The explanation uses the word eligible duties. So it says that we can take the credit of only eligible duties. Where now the eligible duties have been enlisted in explanation 1 and 2, and it severely limits the claim by the SSE of all of those eligible, I mean some of the taxes, because the list is restrictive and not exhaustive. An attempt has been made by the SSEs by filing petitions in various courts challenging that this list itself cannot be taken on the face value. There are certain duties which should be considered to be part of this list, and if the government takes the stand that these duties, though some of the duties are not part of the eligible duties defined under explanation 1 and 2, then that would per se be unreasonable. That is also pending before the courts. There are new litigations which are now coming up beyond the transitional the issue. There is this issue of ocean freight. This is a little bit of complicated, but I'll only, because I'm falling short of time, so I'll sum up. But this is a very, very interesting controversy. This controversy of GST on ocean freight is, it says that if goods are imported from outside the territory of India, and the exporter who's based outside the territory of India, he's sending goods to India on CIF basis, that is cost, insurance, freight included. That would mean that the exporter has basically hired the shipper, has hired the transport agency. That transport agency is also based outside India. The contract is between the exporter and the transport agency, both outside the territory of India. The importer, assuming I am the importer, I am in India, I am only supposed to pay the value of the goods. I'm only supposed to make value of the goods which I'm importing. The question is, because but what the government has done lately is they say that I, being an importer, I am supposed to pay separate GST on the service element of the service rendered by the transport agency to the exporter, because the government says that the nexus is with the territory of India. Now, this question is an important and interesting question, because on the face of it, there is no nexus with the territory of India. On the face of it, it seems to be extraterritorial application, and even otherwise, if we go through the provisions, this kind of levy seems quite unlikely and impossible. Again, Gujarat High Court has come to the rescue of the SSC, and a very, very interesting and a detailed judgment they have held that this kind of tax, so on the service aspect, cannot be recovered. At most, what can be done is that the goods are imported, and if the goods are imported, it's a composite contract. So if the union or the state, they think that they can recover IGST, because it is the case of IGST is recovered by the union. So if the union is seeking to recover, it can at most recover IGST on the composite part. It cannot bifurcate the service element, and it cannot tax that service element stand alone. That is something. This controversy is also pending before the Rajasthan High Court, and some allied controversies have come. There are other controversies. All these controversies are in the nature of basically taking the benefit of the tax credit. So there is this inverted duty structure controversy which is coming up, because by way of a notification, there are certain industries. Inverted duty structure, as you would all know, is like when the output tax liability is lesser than the input tax standing to my credit. So what happens is that since my output tax liability is less, assuming my output tax liability is rupees 10, and the input tax standing to my credit is, let us say, rupees 20. So what happens is that I cannot take the advantage of the entire input tax standing to my credit. Even after setting off, rupees 10 of my input tax credit continue to be there. And because the industry is so, the rate of tax, the structure is so, that I am not ever going to be able to make good of the entire input tax credit. The government came with the notification saying that we will lapse this credit standing to your in your electronic credit ledger, and you will neither get a refund nor you will get the chance to set it off or adjust against other. Now this is again a controversy where they have lapsed my credit, and we are in the process of seeing challenges before various courts. Lapsing of credit is one, then there is denial of credit and imposition of interest rate is another. So there are these kinds of controversies, but most of these controversies are those controversies which are in the nature, they're implementation issues of the GST regime, because it is not what we are seeing is that at times government is becoming expropriatory instead of playing the role as parents patria, instead of taking care of the citizens, and instead of honoring the rights of the citizen. What the government is doing, it is giving no stone unturned to make sure how to exact revenue from the citizens. I'll just close by giving a very, very interesting anecdotal reference to what happened initially when GST was implemented. So there was a set of traders when GST was implemented, a set of traders who were dealing in commodities, especially dals. They were all very happy. They came, they were discussing, oh, the government has been so kind that even though this GST regime is supposed to be so exhaustive, they have chosen not to impose tax on us. They were all very happy. They decided that no, there is no GST on us. And they went to one of the tax consultants and said that, so now since there is no requirement, how is it, how do we do that now? Because there is no liability of tax. So that tax consultant looked through the book and said that what makes you think that there is no liability on you? Why do you think that there is no liability? So he said that, see, there is no entry. There is no entry in the HSN list which uses the word dal, which uses the word pulses. There is no entry. And at that point of time, the tax consultant said that please do not get carried away. It is a possibility that the language may be a little twisted. Just because you don't understand the language does not mean that you're out of the purview, because the language which was used was lentils. So the lentils were within the purview. It was not dal, it was not pulses, but the lentils. So for us to really understand, we will have to see the provisions in detail. We have to go through the entries, and there are a lot of issues which are coming. And as Vikas Bhaiya said that yes, this is not a very simple piece of legislation, and especially so that the way the government is trying to enforce it, the way the government is trying to implement is creating lot of issues. Thank you so much for a patient hearing. I don't know how much sense I made, but I tried.
Lovely, Sharad. I think with such a complex piece of legislation, to put it across, it's difficult. And a lot of people, if you're not in the large business centers, do not get an exposure to taxes anymore because they've all got centralized. So lovely for getting this. I think we have some questions. Pragya has one question. Pragya, can you ask your question before I
Sure, sir. Am I
hear it?
audible?
Yes,
Yes,
please.
yes, Pragya.
Thank you, Sharad sir, for such an insightful session. My question is that there was some cess transition whereof was not originally allowed
Right,
as per
right,
the FAQs issued by the uh, FAQs issued by the government.
right.
But subsequently, I believe Madras High Court has allowed the transition of these cess, specifically Krishi Kalyan cess,
Mm-hmm.
secondary and tertiary education cess. So, how would the non-filing of Tran 1 affect the chances of an assessee availing the credit?
Okay, see, first thing is that the cesses which you have referred to, the education cess, secondary and higher education cess, this is what I was, talking about when I said that they do not form the part of eligible duties.
Yes.
Because the way eligible duties have been defined, these cesses have been kept out of the purview of the eligible duties. And this controversy still remains. I am not sure about the Madras High Court judgment, but if that is so, that they have allowed the credit of Krishi Kalyan cess, then naturally, I think the other judgments which have been rendered by the courts on the input tax credit being a vested right, on the strength of those judgments, the law laid down by the court, probably we'll have to approach the High Court in 226 and tell the court that we should get the benefit of that, this kind of a.
I think there are already issues pending in Rajasthan on the same, and I think
Yes,
Pragya is working with me on I think an issue involvement similar. Is that right, Pragya? I don't recall it exactly.
Yes,
Yes.
precisely,
So,
which is why
so
I
we
got
will
this
have a
confusion.
pronouncement from Rajasthan as and when they decide to hear something like this.
so
We have another question.
Krishi Kalyan says kya bhaiya? Because my
Uh,
matter is in relation to the education says secondary and higher education says that is also pending.
yeah, all of them are pending, and I think I had discussed with you as well, possibly at
Yes.
some point of time. We have another question by from Priyanka Borana. Can you ask Priyanka? Can you ask the question, please?
Yes,
Also,
sir.
the question is
Sir,
available in
can you
the chat.
hear me? Can you hear
Yes.
me?
Yes.
Actually, sir, there is one more issue. This tax was introduced to simplify the indirect system of the country. Then why these late fees? They are collecting late fees only, right? If already there is a interest, then why to impose late fees? Most of the dealers file their return before that time with late fees, and
Yeah.
if there are defaulters, the late
Hmm.
fees collected from these dealers should be refunded.
See, the idea of a fee, interest is basically time value of money. That is a different concept. And fee is against providing a service. So we all know that fee is a quid pro quo. And if I am providing you a service, I will charge a fee. How the government justifies it says that because in the permitted window you were not you were not able to make the respective filing or make the payment. Now we are giving you the facility of extended window. So this is a special service which we are giving. For availing this special service, you will have to pay an additional fee, which is called the late. So,
But sir, this is a discrimination between those defaulters and the dealers who are paying with late fees and even not getting their refund back.
I did not get it. I'm sorry. So they are paying with late fee and not getting the refund of.
So some are defaulters, okay,
Hmm.
and some dealers are filing their return with late
Hmm.
fees,
Right.
correct, and some are
Right.
defaulters who are not even paying late fees. So
Right.
at least who already have paid late fees, they should be refunded
They should be refunded what?
their late fee money.
No, but why should see if, as I'm telling you,
Okay, maybe I'm confused. Yeah, you can clear me. Sorry.
no, no, no. See,
So
normally,
one, Priyanka, you don't have a negative equality. If you have been late, you can't take it back by saying that the government has been late in other instances. So
Hmm.
you are late, it's a specific penalty for non-performing a compliance or non-compliance. It has to be paid, it's absolute. Uh,
Got
I,
it.
I can't see any more questions, but there are two. I should leave with you with some food for thought. Two issues which or observations which Sharad initially had pointed out. Let me just give you some food for thought on that. One was this whole regime of multiple acts, concurrent list, where central also has a piece of legislation and the state also has a piece of legislation, and GST.
Hmm.
Understand the different ways in which the Indian rule-making, law-making body has sort of made statutory laws. You compare some other subjects also which are in working in concurrent field. So you see, one is, say, for example, stamp acts. So you have a central stamp act, and then you have the various states. Originally, most of the states had
Correct.
an adaptation stamp law, and then thereafter they've gone on to their having their own stamp law.
Hmm.
And what happens when there's a conflict? What are the overlapping areas, and how the legislation is framed, and the regulatory mechanism works? Take, for example, another act, which is the CPC, the procedural code, which is essentially a central act, but states are allowed to make amendments, and various states have made various amendments. So for that particular state, that amendment provision works and not this central. So that is another way of how the center and the state legislation regulatory framework works.
We have
See,
another question, sir.
see a third subject, which is, say, mining. So you had the entire mining, the MMDR Act, and thereafter the judgments came in which provided that the entire mining field will be with the center, in which the way the act was drafted. And thereafter, within the act, they provided for differentiation between minor and mineral acts, and for minor minerals, they provided the rule making power to the states, and the states end up collecting those. Also, a lot of things depend on how and where these revenues or impact goes. In mining, all the revenues go to the state. In Stamp Act, again the revenue goes to the state. But in GST, the revenue comes now. That is where I'm coming to the second food for thought, and that's got a lot of constitutional issues and a fair deal of constitutional morality involved. That the framework of GST is that the center gets all of it, but then center has agreed to share it with the states. There are two forms of sharing. One is the center allocates at its own discretion whatever money it has to go to the state. Have agreed on an agreement on how the sharing will happen. And that brings me to the second food for thought for you guys. As Sharad, you had pointed out, that the revenue loss for the states because of the various acts, and thereafter, they got it in the sharing mechanism. And then section 18 of how the compensation is, and also you put in a question that what is its sanctity, whether it will find its place 5 years down the line. Now that's is as much a political question as a legal question. In fact, the legality will only follow the political decision. And
Right.
therein, first see the 2 or 3 factual positions, and then I'll bring it of how the issue of constitutional morality becomes so important, and how the government is going to decide in the next 3 years will shape the way of how our federalism works and how our constitution works. So the question, Pragya, that you'd asked was about cess of, those Krishi Kalyan, etc. And Sharad, you pointed out that they are not part of this levy. Do you know the background of it? You know why? If you want a political answer to it, it's because of the agreements under the GST. The center was obliged to share
Part of, yeah.
revenues with the state.
Right.
Why? First, the question is why that happened and why this ambiguity. It is part of a very interesting field. It is legislative negotiations or negotiations through legislation for the federation of the country. So what happens is when the taxes are to be given away, each state is fighting for it, that this will be my share, this will be my share, or what will happen. And it'll depend on how they agree or not agree, in what form they agree to support the center. So the center enters into a negotiation with the states, which is in the form of a legislature, statutory form. It's kind of a legislative negotiation that if you support us, this is what we give you. And that is what finds place in the sharing of compensation. And very interestingly, center has now, after 5 years, if the center is all too powerful, like in the current status, they can simply do it away with, because we are not in a position to go back to the old regime. Another interesting thing in this is that for the experience of the first few years has been that the center has fallen short of its targeted GST collection. So they are finding it extremely difficult to honor their commitments to the state. And whatever money that they have, they will possibly have to give to the state. So a very unique thing was designed to bring in these cesses, which are not under the GST and are all central cesses, so that the entire control is with the center and they do not have to share it with the state. If they are going to give it, it will be like if any state comes with a begging bowl or with a negotiation power, they will give a larger share to it. It's a fantastic political device. At least all of us as lawyers should understand, yes, the application of law as lawyers will do, but we should also understand what is the thought behind it. So it is essentially these cesses are carved out. We all talk of Swachh Bharat and education cess. These are all narratives given by the center. Essentially, the target is to get funds which are under their control. And then, as we know that yesterday, I think Baljinder had very clearly, spoken about this, that laws would be depending on how they're executed. Even if you don't have a power, the person in power will find a way to exercise it. So this is exactly the same thing. But now comes the question, which is a larger jurisprudential question and also governance question, is that with this background, what will be really tested is the constitutional morality of a parliament. That at the end of the 5 years, whether they will agree to give their share to the states or they will try to usurp. Because if they want to go on a very central aggregation of power, they wouldn't want the states to have a rightful stake in it. And this is the biggest threat to the Indian federalism today, that we are very quickly moving to being a unitary form of government. And also, these are normally tested. Theoretically, we say that constitutional morality could be tested in any sphere. But for courts and the parliament, it normally gets tested only taxes, because it is there. It is for giving up something. It is in those areas that it is the government which is going to give up. See, if they show constitutional morality in the sphere of labor and service law, well, the state doesn't have anything to lose. It's a private employer, which is the larger one. If they have anything on access of justice, it's between two people who are fighting in. But when it comes to taxes, it is there on budget which gets affected. And we all know that the eventual power of this state or any government is only as much as the resources it has. And the resources is equal to the budget that it has. So it will be a great test for the Indian Parliament and the Indian courts, because Indian constitution will only be, we had discussed in the last few days that any country's constitution will only be as good as its constitutional courts, because they're the ones who are going to expound it, they're going to interpret it. So it will be a huge test in the coming times when the GST regime, the next phase of transition is coming in, whether they are able to stand true to the test of constitutional morality and retain the federal structure in the desirable state or move towards a more central authoritarian regime. So that's the sort of thought that I wanted to leave you with.
We have a question from Sanjeet sir.
Oh, lovely. Oh, I sorry, missed that. Hi, Sanjeet. Great to have you here. Please have your question in. I can see it now.
Good morning.
Morning,
Good
Sanjeet.
afternoon.
Good to have you here.
Yeah. Happy that we are organizing this and being a part of the erstwhile Bali and Susodia Associate, which is now turned up as a legal sphere. I'm glad to see all this happening. Sharadji, namaste.
Sir, pranam, sir.
A piece of compliment that you were amazing today. This was a complex subject, but how effortlessly you have explained shows that what command you have over the subject.
You are too
As
kind.
equal, I'm known for that I'm a biggest critic. One small piece of complaint also that you have explained so many judgments which were in the favor of the SEC. You should have got poor ASG and poor government councils also.
Sanjeet, you got late for filing the caveat.
Yeah, okay. I'm sorry. Yeah. One small question, Sharad, what do you think that in this current pandemic, each and every state saying that the center is delaying the compensation, GST compensation, which could have been used by the states to deal with the situation. So what is the law on it, that what is the right of the state to claim it, and whether they can impress or press upon the central government, आपको इतने दिन में देना ही पड़ेगा. मतलब what is the mechanism being given for the state means have this right of GST compensation?
भैया आई थिंक विकास भैया ने हाँ जो पॉइंट विकास भैया ने कहा था, बिकॉज आई थिंक इट इज द सेम थिंग. मोस्ट ऑफ द फंड्स एंड द शेयरिंग इज एट द मर्सी ऑफ द सेंट्रल गवर्नमेंट. इट हैज बिकम बिकॉज दो कॉन्स्टिट्यूशन के अंदर दे हैव प्रिस्क्राइब दैट फाइनेंस कमीशन सेट होगा, वो डिसाइड करेगा. जो कॉन्स्टिट्यूशन अमेंडमेंट भी कहता है दे हैव मेड अ चेंज इन दी parent article in the constitution and they say that finance commission will decide ऐसा कैसे होगा. But अभी तक ऐसा कुछ हुआ नहीं है. It is entirely within the control and mercy of the central government. So people
I'll
keep
add to it, Sanjeet. This is something which is extremely important and something which is in a complete gray area, and it's going to severely test the courts, the parliament, and the ability of the state both to negotiate and the legal position. So I'll tell you what could be situations and what's going to happen. I mean, we don't know what's going to happen. Nobody knows. But the situations could be threefold. One is that the center has got enough money, but it refuses to give or give in time the money to the state.
Yeah.
Second situation would be that the center does not have enough money overall, but the share of the state, it's got enough money to give it to the states. But if it gives to the state, it has no money for itself. That's the second situation.
Okay.
And the third situation would be that it has no money in the sense, forget about itself, it doesn't even have enough money to give it to the states.
Yeah.
Now, three situations. Broadly, what will happen is the situation would be in this second category because there will not be enough money. The sharing ratio is there. So even if there is 1 rupee, it has to be shared, and the center has promised a minimum guarantee. So that will be a tough one. So what questions will come in is, one, whether the states will have enough negotiating power to negotiate with the center, because center will be in an extremely embarrassing position. So again, there will be two situations where the governments of the center and state are the same. They possibly will have to align with the center, but where the governments are different, there will be an open fight.
Yeah, this was my precise question, that does state government have some right to express or have negotiation power?
So this is, if you ask me, and I'm no expert and I don't think it has come to court, this is more like a legislative contract, because section 18 provides for the mechanism of transfer. It's at the end of the day a legislation. It's a legislation. So if somebody flouts that legislation, you have to go to the courts to enforce it. So whether a state will go to the Supreme Court against the center to enforce it, and what happens If all the states come and the center says, I don't have enough money, IBC does not take in central government, but that's the question mark that what will happen. That will effectively mean that the country has gone bankrupt.
But bhaiya, there is this Article 270.
Yes.
This has been amended by the
Yes.
101st Amendment Act.
Yes.
Again, this has, the subclause 2 of Article 270 prescribes the mechanism how the money has to be distributed.
Correct.
And prescribe की definition इन्होंने ऐसे कर दी है भैया. So it says the subclause 2 is that such percentage as may be prescribed of the net proceeds of any such tax or duty in any financial year shall not form part of the Consolidated Fund of India, but shall be assigned to the states within which that tax or duty is leviable in that year, and shall be distributed among those states in such manner and from such time as may be prescribed in the manner provided in clause 3. Clause 3 says prescribed ka meaning is until Finance Commission has been constituted, prescribed by the President by order.
Yes.
Finance Commission है नहीं तो basically President ही कर रहा है.
So if you ask me practically, Sanjeev, they will bring in a legislative amendment to take care of it. But that is where, as I said, of the parliament and the courts also being practical. If they have no money, for example, genuinely they don't have money, then where are you?
How you can say that I don't have the money? When you have earned that 1 rupee, you were knowing that 30 paisa was for the state government.
No, yes, but what happens is with extraordinary circumstances and emergency provisions being invoked, and we're already running in deficit. So that's a longish thing. But take it from me, all countries can go bankrupt. And also what happens is that they were obliged to pay, but they've already spent it. They don't have actual money. So even it's like having a paper decree against a bankrupt person. You may have a decree, you send him to jail, but you can't take out money from him.
Situation in the federal system, the situation would remain the same. The same situation is being faced by the state.
We don't know. They may come out with a legislative amendment. That's the fear that I have, and it could be a required thing also. So we don't know how courts will see it. So if it also, we all know that how different courts will see it differently.
I just wanted to have a clarity. You never know tomorrow on behalf of the state is arguing this thing. I have to face. I just wanted to have.
Yes. Yeah, so that's always going to be a difficult one. So I think we're running out of time. I want to thank, of course, Sharad for a brilliant expose.
Yeah.
And everyone who's attending. I'm very glad that quite a few people have started coming in. We're very happy. So from tomorrow, we change a little bit of track. So far, for the last few days, I think almost 2 weeks, we were mostly doing things on constitutional issues or commercial or with related to property, etc. We had land revenue yesterday by Baljinder, and we had taxes today by Sharad. So for the next few days, we change track. Tomorrow we have Salman, who's taking us through the protection of women from under the Domestic Violence Act 2005. And on Wednesday, we have Sanjeev Bhai Saab talking to us on the sexual harassment at workplace. So this will be both fairly large gender issues. And then on Thursday,
I would like to go on the environmental side also, brother, after a few days, if you would allow.
I can't hear you. Sanjeev, can you speak again? We can't hear you.
I said that I love to be talk about the environmental law side also, because I think this is also one of the areas we should touch.
Perfect. We did one small session on it very early on, but you are the authority on this, so we'd love to have you next week. You've already committed to us, so we will be doing that. Perfect. So tomorrow, next 2 days are those, and then of course we have towards the end of the week we have Sandeep doing a few things on writ remedies and stuff like that. So it's good. I'm really happy that people are joining in. Our sessions have gone a little longer, but I think it's okay with discussions. We are happy. Actually, court में बोलने का मौका मिल नहीं रहा है. So that should be okay.
वैसे भी पूरा constructive part से मिलता ही है. इसके बाद तो कोई waste हो रही है.
So Thank you, everyone. We'll see you tomorrow. Tomorrow we just sort of we might change the time by a little bit. We'll just decide in a little while because of court timings in the morning. We'll let you know. All of you are there on the group, and even if not on the group, you're just free to send the link to anyone whom you wish to ask to join in. You're free. The time we'll figure out will be either 11:30 or 12. We'll try and stick it to the same 11:30, but we'll just let you know in a little while. Thank you so much.
Thank you.
Great to have everyone in.
Yeah, for sure.